I'm asking him to look at it. He just testified that he was familiar with it, and I want him to look at it. And I do believe that I will be able to get it into evidence. I know it was put into evidence in the Lozman matter.
Yeah, I'm gonna just Ms. Godot, do you agree instead of, because the formal rules of evidence don't apply, that we can just go ahead and admit the exhibits as submitted by both parties?
Yeah, I don't have any objection.
Okay, I just for to keep it halfway clean.
Yeah, I have no objection to that.
Okay, now, Mr. Ryan, where in your exhibits are you referring to? Because I see it here, and I see there's 137 pages, and it's got both pages. So can you refer us to the exact?
I think, Your Honor, I think it's towards the very end, because I think, Mr. Ryan, correct me if I'm wrong, it was kind of a composite that was initially all the Lozman exhibits, and then towards the end is the Taylor exhibits. So I think if you scroll down towards the very end, and if you come to a blank page that says Exhibit 15, it's right behind that.
That would be correct, ma'am.
Hang on here.
So I had exhibits that were intended for both matters, and then some exhibits that were intended for the Taylor matter only.
I've got it. Exhibit 15. It's Florida DEP letter dated June 18th of 2013.
Yes, it appears to be page 125 of the PDF.
Yes.
Okay.
Yes. Got it. Thank you.
Thank you.
Mr. Guy, are you able to get to that record?
Yes, I have.
Okay. And have you seen that record before today?
Yes.
Okay. Do you know when was the first time you saw this record?
That would have been January of this year.
Okay. And so in this document, on the second page, there's a paragraph number 3 called Federal Review.
Yes.
SPGP, granted.
Correct. Yes.
Okay. And so that specifically refers to the U.S. Army Corps that at that time that this exemption letter was granted, the DEP was notifying us that it had authority under the SPGP program to give approval on behalf of the Army Corps as well, correct?
Correct.
Okay. And do you see anything in this document that indicates that this determination has an expiration date?
The second paragraph says this verification will expire after 1 year and will not be valid. I'm reading the third paragraph under the same section where it says this exemption verification. Third.
The second paragraph under section 3?
Section 3, actually section 3, then 1 to the third. This exemption verification is based on information you provided. The verification will expire, which is the second line, 1 year, after 1 year. Now, this was a letter from 2013, so it expired in 2014, and the permit we're speaking of is 2019. What I asked for was a valid Army Corps approval at the time of the application.
Sir?
I can't both speaking at the same time.
Sir, doesn't the sentence say, if site conditions materially change, it will expire, this will expire after 1 year and will not be valid at any other time if site conditions materially change. Isn't that what the sentence says?
Again, sir, this was 2013, and I have no knowledge of the permit application that was denied by the city in 2013. So this is a document I'm looking at. It did not say it was valid at the time that the permit was issued.
And at the time that you had this, Mr. Taylor also provided you a 2019 DEP letter confirming that nothing had changed and that the activity was still exempt.
I don't recall seeing that letter, I'll be honest. Is it a part of this package or is it somewhere else?
I'm gonna move on for a moment. Do you recall there being any issue as to whether or not Mr. Taylor had established a principal use for his property?
I remember him speaking of having a floating home, if that is what we're talking about, as being the principal use of his property.
Okay. And so is there any reason why there would have been any question in the city's mind as to whether or not he had a principal use for this accessory structure?
I do recall there were pictures of a floating home, and my memory is now refreshed from that meeting. Is that's one of the things that we discussed also about his use being a primary use being a floating home, and we also asked him to have that floating home either at the location or documented, stating that that was the principal use of the property.
Okay. And in the info dump, as you called it, did Mr. Taylor supply information confirming that the principal use would be a single family floating home?
He did show that. Yes, he did.
Okay. Did you get a chance? You know what? Let me go. I know. If you would go to back to the city's volume 2 and go to pages 30 and 31.
Yes, 30.
Okay, and in mine, page 30 seems to be page 2 of a letter, and page 31 seems to be the first page of that letter. It's a March 4, 2020 letter. Is that correct? The order, it's a 2-page letter and the pages are out of order.
Page 30 is the second page, and 2 of 2, this is 4. Yes, it seems that way.
Hang on, gentlemen. Hang on, gentlemen. I'm trying to pull it up here. Hang on.
Thank you.
You said it was the city's Is that the code or the permit file?
Permit file volume 2.
Permit file volume 2. Thank you. Go ahead. I have it. I'm sorry.
Okay. Mr. Guy, do you have it?
Yes,
Pages 30 and 31. And am I correct that page 31 is the first page of that letter and page 30 is the second page of that letter?
Mm, yes,
Okay. So starting on the first page of the letter, I see that this has got to do with the dock permit, right?
correct. Yes,
And if I understood your testimony earlier, the reasons why the wall, driveway, aprons, and electrical permits were revoked was substantially the same as the reasons why the dock permit was revoked. Is that correct?
very similar.
Okay. And we'll get into the differences in a little bit, but I'm looking at the first paragraph and you list out some things: compliance with regulations stipulated in 1, the Florida Building Code, section 105.4.1, permit intent; 2, the city's comprehensive plan; and 3, the city's zoning code.
Right.
And what were you referring to when you mentioned that the city's comprehensive plan? What part of the comprehensive plan was the dock not compliant with?
Okay, so I'm gonna, there are 2 reasons I believe this permit needed documentation. The first being a Army Corps valid permit at the time when the permit was issued. That has to do with my expertise, which is the Florida Building Code. The second being the zoning deficiencies, which I will punt to Mr. Gagnon with regards to determining the correctness and the consistency for the stuff that are lacking zoning. The zoning department needs to deal with that and say whether the documents are correct or not with regards to zoning. I'm not a zoning expert. I've never claimed to be, and I would defer that to someone else with that expertise.
Can I garner from your answer that this letter that you signed on March 4, 2020 was not written entirely by you?
Correct. There was much input from senior city staff, and my direct supervisor at the city was Mr. Gagnon.
Okay. And just to be clear, at the beginning of your testimony, there was some confusion where you said that your supervisor, you said your direct supervisor attended the November 5th meeting, and I thought that then you said that Mr. Gagnon was your supervisor, your ultimate supervisor, I think. And now you just called Mr. Gagnon your direct supervisor.
I said at the city. At the city. This person at the city who I report to as a contractor is Mr. Gagnon. My direct supervisor for the company that I worked for at the time, Cap Government, is Mr. Dewitt Delaney. And I
Okay,
just
so-
said in my statement that you misquoted me, that my supervisor at the city is Mr. Gagnon.
Okay, so the confusion is that the term direct supervisor applies to Mr. Delaney in one instance and Mr. Gagnon in another instance.
That's not confusing, sir. I'm a contractor and I report to Mr. Delaney with regards to stuff having to do with building official, with stuff directed at the city.
Okay.
Where I'm assigned as a contractor. The person who I report to is Ms. Gagnon.
I understand, sir, but with all due respect, when you use the same phrase to refer
No,
to
sir,
two
I
different
don't
people,
use it loosely. I state at the city.
excuse me, I was speaking. Do not interrupt me while I'm speaking.
But
Let me
do not
finish my
misquote me,
statement, my
sir.
question.
Okay,
Do
gentlemen.
not put words in my mouth.
Hang on, guys. Hang on. Ask the question. Answer the question. Let's be respectful here. Thank you.
Mr. Guy, I was explaining, sir, not a question. I was explaining that when you use the same phrase to refer to two different people in two different instances, it can be confusing to those of us that aren't familiar with how you use those phrases, and that I will be careful going forward when you use the term direct supervisor to determine whether or not, for the record, you are referring to Mr. Delaney or Mr. Gagnon. Are we understanding that when you use the term direct supervisor, I will need to ask for that clarification?
Very well, sir, but you must give me the latitude. I did say at the city. I said direct supervisor at the city.
Okay. So, to be clear, Mr. Delaney did not participate in writing this March 4th letter, but Mr. Gagnon did.
The letter was drafted by me, and it was actually sent to Mr. Gagnon and to Mr. Delaney also for review before edits and final signature.
Do you know who added in the first paragraph the phrase "the city's comprehensive plan"?
I'll be honest, I don't remember exactly when that edit came in. I can't point to the person right now. Maybe in a few minutes I'll remember, but right now I do not.
Okay, so let's go down into the background. There's a paragraph numbered 1, identification of the primary use on the property. Do you see that?
Yes.
Okay, it's in the first paragraph. The last sentence says, to date, the applicant has not characterized the primary use, and the city has no evidence of an approved primary use on the property. And how do you square that with your testimony that Mr. Taylor did document that the primary use was the floating home?
I would say that document also went to the zoning department, and it was for them to make that determination if the documentation was appropriate, not for me to make a zoning determination, sir.
Okay, so you're not making any, you were aware that Mr. Taylor had said that his primary use was a floating home, but you put this in there at the zoning department's determination.
Correct.
Okay, so, okay. It goes on in a paragraph number 2. Oh, I'm sorry, this is important. The second paragraph in number 1, it says, The city had previously received an application for a dock permit at this same property in 2013. You see that sentence?
Yes, I do.
Okay, and you wrote this letter
Mostly, yes.
and you signed it
Correct.
and you knew what was in it before
Correct.
you signed it.
Yes, I did.
Okay, so at the time you signed it, you knew the reason that that application had been denied was because Mr. Taylor had not at that time established a primary use.
Again, sir, I did not have the documents associated with that permit application in 2013. All I had was information, dates from a database stating that a permit was applied for and denied.
Well, how can you write in this letter that you signed that the reason it was denied was because the primary use of the property had not been provided?
That information was came up, I guess, from zoning also. I can't be very certain about that one. But that portion of the to do with zoning deficiencies.
The Riviera Beach Community Redevelopment Agency agenda for the September 23rd meeting. It is 6 o'clock. Madam Clerk, would you call the roll?
Commissioner Lanier,
Here.
Commissioner McCoy, Commissioner Miller Anderson,
Here.
Vice Chair Lawson,
Here.
Chair Botel,
Here.
also present Interim Executive Director Jonathan Evans, Michael Hago, General Counsel, and Tamara Sagan, CRA Clerk.
Thank you. Could we please have a moment of silence followed by the Pledge of Allegiance led by Councilwoman Lanier?
I pledge allegiance to the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Any member of the public wishing to comment publicly on any matter, including items on the agenda, shall submit their comments by email to RBCRA Clerk Tamara Sagan at publiccomments@rbcra.com. The email shall contain the applicable agenda item numbers along with the precise wording to be read into the record. Explicit language will not be read. Emails without applicable agenda item numbers will be read under the general public comments section. Be advised, public comments will be accepted for each applicable item and the general public comment section until closure is announced by the chairperson or the RBCRA clerk. All emails, addresses, and submitted comments are and will be public record. The RBCRA clerk or designee will read public comments into the record at the appropriate time for no more than 3 minutes. If you have any questions, please contact the RBCRA office at 561-844-3408 or email tseguin@rbcra.com. Do we have any additions, deletions, or substitutions by the members? Do we have any disclosures by any of the members? Thank you. Would someone like to make a motion to adopt the agenda?
So moved.
Do we have a second? Thank you, Madam Clerk.
Commissioner Miller Anderson,
Yes.
Commissioner McCoy,
Yes.
Commissioner Lanier,
Yes.
Vice Chair Lawson,
Yes.
Chair Botel.
Yes, and
That motion
obviously,
carries.
please let the record reflect that Commissioner McCoy has joined the meeting. all matters in the consent agenda under this item are considered to be routine, and action will be taken on one motion. There will be no separate discussion of these items unless the council person so requests, in which event the item will be removed from the general order of business and considered in its normal sequence on the agenda. Would someone care to make a motion to adopt the consent agenda?
No, but I want to pull an item if that's okay, Madam Chair. That's
Oh,
generally.
sorry. Yes, go right ahead. It's
I want to pull MS Factor. I got a couple questions regarding that.
I'm sorry. I don't see what you're talking about.
Under vendor invoices.
Oh, I'm sorry, under vendor invoices. Okay. So you want to pull the vendor invoices, all of them,
Yes.
and that's the particular one. Okay, thank you. Anything else for changes to the consent agenda? Would someone care to make a motion to approve the consent agenda with the vendor invoices removed?
So moved.
Second.
Thank you, Madam Clerk.
Commissioner Miller Anderson,
Yes.
Commissioner McCoy,
Yes.
Commissioner Lanier,
Yes.
Vice Chair Lawson,
Yes.
Chair Botel.
Yes.
That motion carries with the monthly vendor invoices pulled.
Mr. McCoy, you have a question?
Yes, I do. So I was particularly concerned. I know we took action not to extend the 1-year option for MS Factor. These invoices represents the last 3 months. Is there any more that's outstanding, Mr. Haygood or Mr. Evans?
Madam Chair and members of the board, I'd have to defer to probably Ms. Jenkins to provide some insight with regards to if there are any outstanding invoices after these items.
And if I can add a little bit, it seems that we've gotten 3 months worth of invoices. Is that typical? Because, I mean, we do monthly invoices. Is there some reason why we get them all 3 months in one meeting?
Good evening, if I may. Good evening, Chair Botel and Commissioners. The timing was a little off with the submission of their invoices to make our July agenda. And in August, we just had some challenges with getting things signed and processed. What you're seeing are 3 months worth of invoices. We went through and did an accounting to make sure we did not exceed the contract amount. We're expecting a final invoice for September. Their contract ends September 30th of this year.
Thank you. Follow-up question. You know, when we reviewed the contract and we talked about Hubbard Radio, West Palm Beach, and some of the CRA community spotlights, have there been any determination as to how that is determined and who gets those spotlights? I think I've had a discussion, but has there been any determination as to, you know, the eligibility or who exactly, you know, gets selected for the community spotlight?
We have not engaged. The spotlights ended in August, and that was the end of the agreement as we had it with Hubbard Radio. We reached out to people who had received our business assistance grants and others within the CRA. There was no particular process. It was whatever business returned the information. So right now, at this point, we don't have a firm plan to move ahead with this particular program. It's pending further budget allocation.
Okay, and if I can add the comment, and as we should move forward, because, you know, let me tell you, I'm in business and I would love to have free advertisement, but I would never particularly, you know, come down and ask to be placed on the ad. But what I'm seeing is we have a number of invoices where we're basically paying for radio slots that advertise local businesses. And, you know, it's good that we can do that, that offers an overall enhancement of businesses within the district. But what's our return on investment? Can somebody come back from one of those businesses and say they've got an increase in sales? Like, how is our money being spent? and what is the return? What measurables can they bring back to us that lets us know that that's a benefit? So for all intents and purposes, I'm glad this is sunsetting until we can get a better plan as to, you know, if we were to do any kind of marketing or supportive advertisement for businesses, you know, how do we measure that as in terms of the benefit for the CRA or what's returned to the community? So I wanted to be sure of that. And I guess from your explanation, we shouldn't have to worry about having these community spotlights in the month of September on the September invoice for MS Factor. Is that correct?
There are not any for September. And part of the closeout is the assessment tool for the effectiveness of this program. An increase in business, an increase in sales, et cetera, for the businesses that participated. So we hope to bring that back to you with a recap, but it ended in August.
Well, bring it back to us by way of a memo. We don't need to, you know, I don't know if unless some commission member chooses to hear it publicly, but I just want to make sure that I know I've heard it on the radio station, but I've never seen, you know, what the fruits of we spending money on radio slots to advertise local businesses are. But I don't know if it necessitates us bringing back this to an agenda item. But if there's an alternative that you want to propose, I think, you know, I'd be happy to hear it at a meeting. But just the results, I mean, the money spent at this point, and we need to find a better way to make sure that we're measuring the dollars that we're spending. So that's all I have for that item, members. Thank you, Madam Chair.
Thank you.
Madam Chair, now that you brought it up, Councilman McCoy, I would like to hear it to see how that works.
Hear what exactly?
You're saying that should we bring it back to a meeting or should we get it in a memo? Is that what you said?
So, Mr.
Others to go through this information. We also had to send a document to the city attorneys for them to look at it also. So it was quite extensive. So, you know, I mean, it wasn't like we looked at it and 1 minute made the decision. It did take a few weeks to understand. So it was quite extensive is my answer as to why that it took so long for us to come up, you know, with the final determination.
And isn't it true that that document included a copy of the DEP's 2019 letter confirming that nothing had changed, that
I'm not looking at it, no, and I did mention earlier that is not something I can recall at this moment.
Okay. So you don't know as you sit here today?
I can't recall, sir.
Okay. But nonetheless, you wrote in the letter in the next sentence, at this time, neither of these deficiencies have been resolved. You see that?
Where in the letter are we?
There's a one sentence paragraph at the full paragraph at the top of page 2 of the letter. It says, at this time, neither of these deficiencies in the application request have been resolved.
Correct. So, I mean, at the time, that was the determination.
Okay, and I take it to mean that, one, there has been no determination as to the primary use, and two, that because of the Army Corps or DEP permits or both, that the property, the use doesn't comply with the future land use plan.
I'm not making any statements about the future land use. I'm making a statement about the lack of an Army Corps approval. I'm pointing everything having to do with zoning to zoning experts.
Well, I'm sorry, go back to the first page of the letter, the paragraph number 2. It says, the dock application is non-compliant with the future land use element of the comprehensive plan, in particular, the absence of required approvals. So
correct.
What you're saying is that the lack of those approvals made it non-compliant with the future land use plan, as I understand your words in that letter. Is that am I misunderstanding you?
You're not misunderstanding me. I also said that this letter was a collaboration with the zoning department, and that I'm also understanding that there will be testimony from the zoning department today, and I'm punting everything having to do with zoning issues to the zoning experts.
Okay, and then in the there's a paragraph under that that starts with the heading November 5, 2019. You see that? On the second
Yes.
page of the letter?
Yes.
And it says a formal meeting took place at City Hall, was attended by the city's building official and supplemental staff, as well as the property owner, Mr. Taylor.
Correct.
During that meeting, the building official requested Mr. Taylor's address the comments outlined in the April 15, 2019 memo.
Correct.
And we've already established that the April 15, 2019 memo doesn't mention the Army Corps, correct?
Correct.
Why didn't, when you wrote this letter in March, why didn't you say Mr. Taylor was asked to provide the Army Corps permit?
In retrospect, it should have been done, but it wasn't.
You don't think that the property owner is entitled to a fair review and to know what he's being asked to do?
I believe I was very clear in that meeting as to.
And you believe that you're being more clear today than you were in March of 2020 when you wrote this letter?
Can he let Mr. Guy finish his answer, please?
That's sustained.
Go ahead, Mr. Guy.
Yes, so I believe I was very clear what was required, and there was, much confidence that that document, would have been provided. Again, no, in retrospect, I should have been more clear in this letter. That was needed.
Well, how is it that you're able to be more clear today than you were 7 months ago when you wrote this letter?
I believe that we should have been more clear. I mean, I thought it was clear. I mean, you were there at that meeting. You said it was clear. You understood what was needed. And today, we don't have it. And if you have it, send it in. Again.
And then it goes on, below that it says December 23, 2019. It says the building official, Durrani Gay, received an email communication from the applicant's attorney, Mr. Ryan. You see that?
I do see that.
What's correct? Did you receive it on December 23rd, or did you receive it in January of 2020?
Received it in January of 2020.
Why, when you wrote this letter 7 months ago, did you state that inaccurately?
Again, it was a collaboration, and that too should have been more defined. But the letter was dated the 23rd, and it was sent to Mr. Bovell Richards, the assistant who was not in the meeting, and to another email address. And it did take some time for us to actually see that letter. The bottom line is we did receive it. And we're not saying that we did not receive the letter.
And
that's
then
not
you
in
say,
dispute.
I'm sorry, are you done?
Yes, I am done.
Then it says, however, the contents of the email did not address the deficiencies detailed in the planning and zoning memo dated April 15, 2019. You see that?
Correct.
And again, the April 15, 2019 memo did not mention the Army Corps, did it?
No, sir.
So why would you have expected a response to the April 15, 2019 memo to address the Army Corps
Again, sir, sitting in this hearing, speaking with you, I said previously, in retrospect, it should have been clearer. You do have a point. All right.
You are aware that Mr. Taylor received approval from the prior building official, Lady Marge Goldwire, that she had made a determination, rather, that no permit was required for the fill and riprap that he placed on his land, correct?
Correct.
Objection, Your Honor. Is he talking about testimony from the Lozman case?
No, I'm not. I don't think I mentioned testimony.
Can you restate your question, Mr. Ryan?
I asked him, I said, you are aware that Mr. Taylor received confirmation from the prior building official, Lady Marge Goldwire, that no permit was required for him to place the fill and riprap on his property. And he answered in the affirmative. Yes, he understood that to be the case.
And if I may clarify, it was not a requirement of her during the approval documents that I saw.
What do you mean it was not a requirement?
It was not mentioned that a permit was required having to do with the fill in the documents that I reviewed.
She did not require Mr. Taylor to get a permit for that work.
No, there was no mention of that.
Okay. And when you had the meeting with Mr. Taylor on November 5th, one of the things that was discussed was the final order that had been rendered in the case of the city, or I'm sorry, Joan B. Taylor versus the city of Riviera Beach, correct?
Could you rephrase?
When you had the meeting with Mr. Taylor on November 5th, 2019,
right,
one of the things that he mentioned, or that was mentioned at the meeting, was the existence of the final order in the case of Joan B. Taylor versus the city of Riviera Beach, i.e. one that determined that no permit was needed from the city so long as all other necessary permits had been obtained. You were told about that.
I was told about it, and at that time, I had just a basic understanding of it. Now I understand it more clearer, but there was a mention of it. Yes, there was a mention that there was an order.
Okay. And one of the documents that was included in that document dump was a copy of that final order, correct?
That is correct.
Okay. And so when it came time for Mr. Johnson to prepare his notice of violation, he said that the notice of violation was prepared by his team and that he didn't determine which codes and so forth that Mr. Taylor should be notified that he was violating. Did you play a role in giving him what to include in the notice of violation?
This moment, no, I can't remember being directly involved in writing that notice.
Okay. Do you have any information as to how the zoning department, or I'm sorry, the code enforcement determined what things to include on the notice of violation?
At this point, I can't recall how that came about.
Okay. So tell me what I mean, if I understand correctly, the city's taking the position, or that you were trying to communicate in this letter that you wrote on March 4th, that in the absence of establishing a primary use, you're not entitled to a dock permit. Is that one of the things that you were trying to communicate to us in that letter?
Can you rephrase, please?
This March 4th, 2020 letter that we've been talking about, one of the things that you were trying to notify Mr. Taylor of is that in the absence of a primary, not entitled to a permit for an accessory structure.
With regards to issues having to do with zoning, I will punt that to the zoning experts. This is a zoning determination.
Well, does the building official determine what is or isn't an accessory structure?
There's a basic understanding of what is classified at the City of Riviera Beach. The zoning department makes those determinations as to what is classified. They're the ones that make that final determination. And in this case, I'm going to allow them to make that determination also.
So the building official makes no determination as to whether or not there's a principal use for the property when reviewing an application for an accessory structure.
With regards to zoning determinations, which this is what this is, I will refer that to the zoning experts.
Isn't it true that the city regularly issues permits for the construction of accessory structures, even though there is no principal structure already in place, i.e., or by way of example, somebody comes in and they apply for a permit to build a new house, and they also apply for a permit for a dock, and the city issues those permits. At the same time, it doesn't require the house to be certified for occupancy before it issues the dock permit. Isn't that correct?
While I was at the City of Riviera Beach as a building official, I can't recall any permit that I dealt with in that fashion.
Can you recall any time when you required somebody to complete their principal house and get a CO before they could get a dock permit?
I have not been involved in any case where someone needed to apply for a I can't recall being involved in such a case or permit the process.
Okay. Let's talk a little bit about the wall permit.
Yes.
I think you said that it was, primarily the same reasons that, the wall permit was revoked. A wall is not an accessory structure, is it?
It can be. But again, that's up to zoning to make that determination.
So it's just, you got an experience with this that you can relate to where you've been involved while you were at the city with the determination of whether or not a wall is or isn't an accessory structure?
Could you repeat?
Do you have any experience at your time in the city where the city made a case-by-case determination as to whether a wall was or was not a quote-unquote accessory structure?
Whether a wall was an accessory structure or not. I mean, again, the processes at the City of Riviera Beach is the zoning department generally reviews documents relating to a fence, and they're the ones that make that determination. even before it comes to the building department. The building department, my office, my portfolio dealt directly with structures having to do with the construction of that fence that we're talking about in this theoretical case. And the zoning and the classification would go through and be approved by zoning prior to my office looking at it.
So it's your understanding that the reason that Mr. Taylor's wall permit and driveway permit and aprons permit were revoked or rescinded is because of zoning issues?
Yes, and because the information wasn't forthcoming, as requested.
What information wasn't provided with regards to the wall?
Could we find that letter? I mean, I did send us a separate letter about that if we're going to talk about it.
There's, I think it's.
Oh, the next one.
Pages.
It's actually page
29 and 32.
29 and 32, okay. Okay, correct.
March letter?
Yeah, it's dated March 3, 2020, and it's written by Mr. Durrani Guy to a gentleman named Kerry Kincaid.
I got it. Thank you.
And it's spread out. It's on, first page is on 29 and the second page is on 32. So I've got the letter there, and it says, Mr. Taylor was requested to provide additional information associated with the subject permit. And then on the second page, it says inability to satisfy planning and zoning comments.
Correct.
Can you tell me what specifically, what planning and zoning comments Mr. Taylor failed to satisfy with regards to the wall?
This would have to go back to the letter, the memo from Mr. Gagnon, and these issues are specifically zoning issues that were not addressed and satisfied by the zoning department.
Okay, and that again would be the April 15, 2019 memo.
Correct.
Okay, so can we go back to that? I think it's pages 41 and 42. I'm sorry, 41, 42, and 43.
Okay.
Wait, no, that's not correct.
I think it's at 45, 46, and 47.
Yes, ma'am, that is correct. Thank you. Can you tell me what in this memo pertains to the wall permit?
Again, this is a zoning determination, and basically, if I was supposed to summarize my letter, it would say zoning has not approved this application and it is therefore denied. I mean, it's totally based on zoning or not approving the application.
Well, I understand that, but you said in your letter to Mr. Kincaid that failure to respond to information as per the April 15 memo, and when I go to the April 15 memo, it says it's specifically talking about application 19-00746, which is the dock. And so, I mean, what exactly was Mr. Taylor told to give you with regards to the wall that he didn't give you? Or what zoning comments were you aware of when you wrote that letter to Mr. Kincaid that he hadn't complied with?
Again, it all had to do with just zoning deficiencies that were not satisfied. And again, zoning department will have to clarify that one.
So you were just directed to write this letter. You didn't make a determination that the wall was problematic. You were told to write a letter saying the wall is problematic.
I didn't say the wall was problematic. I said he did not satisfy zoning requirements.
Okay. And you have no knowledge of what zoning requirements Mr. Taylor was advised to give information on?
That would be based on, again, I was told this letter did cover some of those, but again, I'll put that to the zoning experts to deal with the zoning deficiencies on that.
Okay. When you say this letter, you're referring to the April 15, 19?
No, the letter that I sent
okay,
stating
so
that there were zoning deficiencies.
Let's go back to that. Starts at
29.
Page 29.
Correct.
Can you tell me from this letter what Mr. Taylor had failed to provide anybody with regards to the wall, the driveway, the aprons, and parking papers?
This letter is a denial letter. And it points to the in-person meeting from November the 5th that additional information was required.
Well, sir,
it was not listed here. And again, I've said that previously that we should have been clearer with stating exactly what was needed and documenting all the points that were needed.
Did and as we sit here today, this letter, well, let me ask you one more question. Why did you choose to send this letter to Mr. Kincaid and the March 4th letter to Paul Jablonski when you knew from the November 5th meeting that I was Mr. Taylor's letter attorney and that I was responding to the city's request for additional information?
Well, generally, we respond to the applicant of the letter. And I mean, again, that's how we respond. Right now, I can't think that we had direct communicate, direct. Maybe it's there, but I never noticed it, that we had a directive, a clear directive from you or your client that all correspondences should be sent to you. I can't think of seeing that anywhere. But by default, we send notices to the applicant based on the permit application form.
So even after this meeting with Mr. Taylor and his attorney, receiving this very significant document dump, and what you do next is you wait a few months and just send denial letters. You don't say, Mr. Taylor, let's be more clear. We need something with regards to the wall. You just send out the denial letter. And you send it to the contractor instead of Mr. Taylor's attorney. Correct?
The Florida Building Code requires that we send notices to the applicant, sir.
Okay. You cite in there a section 105.4.1, permit intent. It says a permit issued shall be construed to be a license to proceed with work and is not authority to violate, cancel, alter, or set aside any of the provisions of the technical codes, nor shall issuance of a permit prevent the building official from thereafter requiring correction of errors in plans, construction, or violations of the code. Every permit issued shall become invalid unless the work authorized by such permit is commenced within 6 months after its issuance, or if work authorized by such permit is suspended or abandoned for a period of 6 months after the time or work is commenced. My question to you, sir, is why did you include that language in your letter? That's building code section.
Right, it is. So the point is, and the most important detail in that paragraph is that a permit, even though issued, the building official still has the latitude to request additional information from the applicant, which is what this is all about. We asked that the applicant meet the bar for the zoning approval, which was not granted at the time the permit was issued. So we required the applicant to meet the requirements for the zoning deficiencies.
Well, actually, the word zoning doesn't show up in that paragraph anywhere, does it?
It does not, sir.
It gives you the authority to revoke permits or to require changes based correction or errors in plans, construction, or violations of this code. Can you identify any violation of the code that pertain to the wall, the pavers that he had plans for, or the aprons that he had plans for?
There is a statement on every permit that is issued that the permit is subject to other governing agencies. In this case, the zoning department is considered another governing agency, and approval was not granted by the zoning department So that is how I view this permit, that it needed to meet the zoning requirements, which it did not when it was issued. It was rescinded by Mr. Delaney, and time was given for the applicant to meet the zoning requirements.
Let's be clear about something. Mr. Delaney, he placed the permit back into review status, correct?
Correct.
And in this letter in March, these letters in March is when the permits were actually rescinded, correct?
In March. Yes.
Okay. So Mr. Delaney put them in review status. Later, you rescinded them. And it's your understanding that the reason you rescinded the wall, driveway, and driveway apron permits were purely because of the city's zoning requirements.
That is correct.
And you don't know what zoning requirements the city was referring to at that time.
I'll leave that to the zoning department to clarify those.
My question is, did they ever indicate to you that it was because of the comprehensive land use plan, specifically because this land was designated special preservation?
I can't say while I'm talking to you, I'm thinking if there was a document previous to this one that we had sent out with some notes, but specific to that, again, zoning would be the best agency to deal with what those exact deficiencies are.
And with regards to the temporary power pole, same answers. I mean, you were told that Mr. Taylor would not be allowed to recommence construction at any point, so the temporary power pole had to come down.
The 180 days had expired, and there was no active permits at the location. Therefore, that permit too was rescinded.
And the reason there were no active permits is because Mr. Delaney had issued a stop work order, prevented Mr. Taylor from completing the work and closing out the permits, and you later rescinded them because primarily you didn't understand what the status was of the Army Corps application.
You've said a lot, and I'm not going to agree with anything that you just said. My understanding is Mr. Delaney gave the applicant time, and we gave 2 extensions to allow the applicant to submit and meet the requirements for the zoning deficiencies, how the permit was issued without a zoning. While I was building official, there was not one permit having to do with a fence or driveway that we issued without having zoning approval. And it was curious to me, and we gave the applicant time to meet these requirements. The applicant did not meet these requirements. And that is why, there was no active permit. A temporary power pole is a temporary structure. It's not a permanent structure. It's built in a way that it deteriorates. It's not a rigid construction. Usually in a year, it has to be replaced or removed. As a matter of fact, in many places, the temporary pole is given a final only when the temporary pole is removed. So that is to clarify that the electric is not a permanent fixture. It is there only for a short time. And then once the pole is used for the time it was intended for and removed, then another inspection is done and a final is done when the pole is finally removed. It's done slightly different, but it is still what's called a temporary. It's not a permanent fixture.
And you heard, I think, at the last hearing, you overheard Lady March Goldwire testify that she has a different view of how temporary power poles are dealt with, correct?
We have to talk about the time. There cannot be two building officials at any jurisdiction at any one time. I respect what she did when she was there, and that was her time. While I was there, I was the only building official, and opinions do vary from building official to building official.
Are you aware of what the current building official's opinion is on this issue?
I do not.
The city's? Okay. Are you aware, never mind, let me see if I can wrap this up. Let me just check my notes here. Is the definition of a dock, is that something that's in the building code or is that something that's a zoning determination?
The definition of a dock, you mean whether a dock is an accessory structure or not?
I mean, the city has in its code a definition of a dock. And my question is that zoning code or is that building code?
That would be a zoning code.
Okay. Have you ever spoke to any of the city council members with regards to Mr. Taylor's use of his property or the status of his permits?
No.
Be fair to say that everything that you know about the permits in question that occurred prior to November 4th or 5th of 2019 is secondhand knowledge, stuff you learned from other people after you started working for the city?
Mostly what I have is by researching the documents that were available to me and doing searches in the database, as well as using PAPA and making interpretations of the site myself. I did do a lot of research. After the briefings by Mr. Delaney prior to starting, I would seek advice from him about certain decisions I made. But in terms of learning, most of that was from me. Very little came from a third party.
in going back to your March 4th, I'm sorry, yeah, March 4th letter, on the second, let's see. I'm sorry, I think I've got it wrong. I've got page 32. I'm sorry, page 32 is the second page of the March 3rd letter.
Okay.
So it closes out by talking about, I mean, it's dealing with permit application 19-00743, which was the CMU wall, driveway aprons, parking pavers. But it closes out and includes, it starts discussing the pilings and unpermitted fill. Is there a reason that you included pilings in your letter to Mr. Kincaid?
To summarize, my point was any unpermitted improvements to the site needed to be removed.
Okay, so in the how did you determine that Mr. Taylor needed any permit from the city for his pilings?
There was an associated permit having to do with the dock.
Right, that's the dock, but these are just pilings, these are not a dock. What was your determination that any permit was needed for the pilings?
So there was a permit application that requested a dock, that it was determined because they did not have the proper Army Corps approval and could not present that documentation, that permit was rescinded. And it so happened that the positions of these pilings that were placed on the site were in the exact locations matching the proposed dock permit that was revoked.
Okay, so you took it on yourself to determine as a building official that if you need a permit for a dock, that you must also need a permit for the pilings that are on site.
The pilings on site exactly matched the foundation structure of a application that was rescinded.
Okay. But as you sit here, you're not aware of whether any permit is required from the Army Corps for those pilings.
That was
you're
never
not
my
aware
statement,
of whether
sir.
or not, well, are you aware whether or not any permit is required from the Army Corps for those permits, for those pilings?
I've never investigated that, and that is not my statement right now.
Okay. And do you know whether or not there's any permit needed from the city for pilings?
I'm not discussing that. That's not something I'm thinking about at the moment. All I'm saying is that there were piles that were added to the site that lined up exactly with an application for a dock.
Okay. And do you know, you also talk about unpermitted fill, and we earlier addressed the fact that you were aware that the prior building official had advised or confirmed to Mr. Taylor that no building permit was needed for the fill that he was putting on his property. Do you have a different opinion? Did you conclude that he needed a permit for that fill?
Again, if there was fill that was put there that was unpermitted, it needed to be removed. That was the statement there.
Right, but why? I mean, is it because a permit was initially required?
I never stated that.
Okay, so if no permit was required, why would he have to remove it?
As we speak, I don't know that Mr. Taylor added fill to the site.
Okay. But if he did, you don't know whether or not he did or didn't need a permit.
I'm not making that statement.
Okay. I have no further questions for this witness, Judge.
Okay, Ms. Godot, I'm sure you want to redirect.
Yeah, thank you, Your Honor. All right. Mr. Guy, let's go back to Jeff Gagnon's memo from April 15th, 2019. That's at the city's exhibits, permit volume 2, pages 45, 46, and 47. Do you have that up?
Yes.
All right. So this memo was the memo that responded to the dock permit application issues from the zoning department.
Correct.
Okay. So in this, Mr. Gagnon's going through the zoning deficiencies for the dock permit. Is that correct?
It would seem so.
And from your understanding, based on your research and knowledge of this issue, did zoning ever have an opportunity to review this permit application before it was issued by the prior building official?
Objection, Your Honor. Foundation, she's asking him about something that occurred before he became a building official. And I think she needs to establish how he would have known that before he answers the question.
Your Honor, we've just gone through 2 hours of cross-examination where Mr. Ryan asked extensively about the prior building officials' acts and what Mr. Guy knew about those acts.
Yeah, I'm not gonna, you can go ahead.
Well, sir, I just want to go on the record and say that what he testified to was all he did was review records and learn things from third parties. So be it.
Okay.
So, Mr. Guy, when this permit was issued, is it your understanding, based on your research of the records and in talking to people, that zoning was never given an opportunity to review this permit application?
Whatever was given was limited, and they did not make a final determination before it was issued.
Okay, so Jeff Gagnon's memo from April 15th, 2019, addressing the zoning deficiencies for the dock permit application?
It would seem so. It refers to the dock application.
Okay, and on page 2 of 3, that's page 46 of the exhibit, under subsection 4, additional questions, what's that code section that Jeff is citing to there?
It says City Code Section 31. So that would be from the city's municipal code.
Okay, and that deals with residential docks?
That's what it says.
Okay, and on page 3 of 3, which is the last page of his memo, the city's exhibit 47, there's a little subsection 3 there, Roman numerals. What does that say?
It says, has this project received permits from DEP and/or all other applicable regulatory agencies?
All right. So when you met with Mr. Taylor and his attorney, Mr. Ryan, on November 5th, you went through this memo, as you stated, line by lines to talk about the dock deficiencies.
Correct.
And as you testified, one of the items that you pointed out that you found most prominent was the lack of a U.S. Army Corps of Engineers permit.
Correct.
But you went through this entire memo with them.
Yes, I did.
So they were on notice as of November 5th that not only would they need an Army Corps of Engineers permit, but perhaps all other applicable regulatory agencies.
Yes, we read it line for line.
Okay.
What we pretty much did.
Okay. Did you prepare a timeline for this property based on your research of the city's records?
I did.
And is that timeline at page 22 and 23 of the city's permit file, volume 1, pages 22 and 23?
I actually have it as 21 and 22. Yes,
Okay.
yes. Correct.
23, on page 23, the
Can
date
you
at
hold
the
on a
top.
second while I get to this?
Oh,
What is
I'm
this
sorry.
called?
Yeah, absolutely. This is in the city's permit file, volume 1. And I'm at page 23, which is the page on the PDF and also the page at the bottom.
Page 23?
Correct.
Okay, I have it. I have it as well.
I'm sorry, I was in the wrong volume 1. I'm looking at a page 23 that is a Riviera Beach, Florida Code of Ordinances, and then I'm looking at another page 23, which is a couple of photographs. How many
you in the-
23s are there?
There's the permit file, volume 1. You may be looking at the code file, volume 1. And you're also, it looks like, I think you're looking at the code sections.
Okay, I found one that appears to be a timeline.
Okay, so
Got
at the top, the first date entered there on the top of page 23 is February 12th of 2020. Are we all on the
Yes.
same page? Okay, all right. And then if you go back a page to page 22, it appears that that's sort of where the timeline starts with a date of March 6, 2019.
Yes, I'm there.
We're all on the same page?
No,
Mr.
no,
Ryan?
my
22?
22.
22 looks like it's kind of cut off.
At the top, there's 7/29/19.
Yeah. Yes, I have that.
Okay, all right. Yeah, the
I think
22
21
is,
and 22 are the same, by the way. If your
Yes,
22 is
yes.
cut off, 21 and 22 appear to be duplicates.
Right.
yes, they are. So, Mr. Guy, did you prepare the dates and the timelines that are shown on page 22 and 23?
Yes.
Okay. According to this timeline, when was the temporary pull permit issued?
For 10/19.
Okay, so April 10th of 2019.
Yeah.
And you testified on Cross about the city's process being a little different. What is the city's process with a temporary pole permit? What does that involve?
It's an application that goes usually directly to the electrical plans examiner. It's that one is not usually one that goes to zoning.
Okay.
And that one plans examiner, would generally make that determination.
And in this case, it looks like B. Richards approved the permit. And then according to your timeline, what happened next with regards to the temporary pole permit?
I guess once it was issued, it was finalized on 7/9/19. They had a final inspection, right?
So then under the city's process, what happens with a temporary pole permit after it's been finalized?
According to what the city of Riviera Beach does at that time is when the meter is installed and power is given to the applicant.
And under the city's process, how long can that temporary pole be in place?
Generally, it's 180 days, but if it's on a job site at the conclusion of that project is when the pole is removed.
Okay, so if we go to page 28, which is your March 5th letter. Is everybody there?
Give me a second. You're in a different file, okay? March 5th letter, page 28, yep.
Your Honor, that's volume, I think it's in volume 2.
Okay.
Mr. Guy, do you see that your letter?
Yes.
Okay. In this letter, what are you explaining to Mr. Barrett?
That his pole shall not exceed 180 days at the location.
Okay. And who's Mr. Barrett?
Again, that is the applicant for the power pole, which is what we're required to do to notify the applicant.
Okay. And I'm sorry, if we go back to permit file volume 1, page 24.
Right.
What is that?
That is the permit application for the power pole, the temporary power pole.
And how do you know it's supposed to be a temporary pole?
It says so in the description, hook up a temporary pole with 1 GFI outlet and a photocell light.
Okay, so as of March 5th, you notified the applicant that the permit was now expired.
Correct.
And you gave them until April of 2020 to remove it?
Based on the letter, yes.
Okay. All right, so going back, and I'm sorry, I'm flipping around so much. If I would have done this in a different order, but if we go back to the timeline, which is in volume 1 of the city's permit file, pages 22 and 23. Let's talk about the permit for the wall, fill, driveway, and pavers.
Okay.
Do you see on your timeline when that was approved?
Could you restate?
Do you know from your timeline when the permit, which ends in number 43 for the wall, fill, driveway, pavers, was approved.
Okay. The approval for 743. I have March 6th,
What year?
2019.
Okay, all right. Then at some point, that permit was placed back into a review status. And I would direct your attention to the city's permit file, volume 2. 29. And that would be 29, looking at the page numbers at the bottom, not at the PDF number.
Okay.
Are you there?
This is the letter to Kerry Kincaid?
Yes, dated March 3rd.
Yes.
Mr. Ryan, are you there?
I am.
Okay. In this letter, can you tell us when the permit was put back in a review status?
July 29th.
And was a stop work order issued on the property?
Yes, according to my records, on August the 3rd.
And when you issue a stop work order, is that posted at the property?
Yes, it is.
Objection, Your Honor. There's no indication that Mr. Guy posted the stop work order. You know, if she wants to ask him about what Mr. Delaney does, I think she needs to establish that he knows how Mr. Delaney does things.
Your Honor, I can certainly ask the witness generally, in his experience as a building official, what happens with a stop work order.
I think I agree with you. Ms. Godot, you can
Thank
continue.
you. Mr. Guy, generally, in your experience as a building official, how is a stop work order issued?
We must post the site. There's no way for us to issue a stop work order without you know, making it clear and in writing that it's posted. Generally, it's a very visible paper, clearly notating the address and the reasons why the stop work order is placed.
Okay. When you met with Mr. Taylor and his attorney, Mr. Ryan, on November 5th, were they aware of the stop work order on the wall permit?
I
Objection, Your
can't.
Honor. Foundation got to establish how he would know what Mr. Taylor or myself knew.
Yeah, I would tend to agree with him there, Ms. Godot.
Okay, all right. At your November 5th meeting with Mr. Taylor and Mr. Ryan, did you talk about the permit that had been issued for the walls and the driveway, the fill, and the permits at the property? I'm sorry, the pavers at the property?
It was discussed, and Mr. Delaney was in that meeting. So, you know, I think he did much of the presentation. I mean, again, he was, you know, the sitting building official in transition at the time.
Okay. And do you recall from that conversation if Mr. Delaney told them that the stop work order had been issued?
I can't remember the exact details. I couldn't say affirmatively if that was discussed.
Do you know if in that conversation, the fact that the permit had been revoked from an approval status to a review status was discussed?
I'm certain that was discussed.
Okay. So as of November 5th, Mr. Ryan and his client were aware that the permit was no longer in an approval status.
Yes, that was clear at that meeting.
Okay. And at that meeting, were they directed to address that review status of the permit?
Yes, that's what that was. It was basically to plot a path to say these are the steps that we need to take so that the permit can be renewed and work continued at the location.
Okay. And going back to your March 3rd letter of 2020 on page 29 of the city's permit file, volume 2, did you outline what occurred in that November 5th meeting?
Sorry, which page are you on?
It's page 29 of the city's permit file, volume 2. It's the March 3rd, 2020 letter from the building official to Carrie Kincaid.
Could we clarify when you said, did I outline, in what form?
Did you discuss the November 5th meeting?
With whom?
In your letter.
Oh, so does the letter dated March 3 point to the November 5th letter? And the answer is yes.
Okay. And was there a discussion at some point about giving them extra time to submit further documentation for that permit?
Objection, yes. Your Honor. You know, I've given a lot of leeway here. Mr. Guy is not her adverse witness. She's been leading and leading and leading, providing him the answers to his questions. I think, you know, in all fairness, I asked him what was discussed at the November 5th meeting. Yes, Judge.
Brian, in all fairness, in your cross, you've basically had him go through letter by letter, by line, had him reading it. And all, you know, granted that you can lead on cross, these documents have been admitted into evidence. Asking questions related to the documents, I'm not gonna, you know, stick firmly to the requirement that.
Judge, I think you misunderstood me. She asked him in his mouth as to what was discussed at the November 5th meeting, not what the letter says, what was discussed at the November 5th meeting. And I also asked him directly what was discussed at the November 5th meeting. He had limited knowledge. It expanded as it was refreshed, but now she is putting words in his mouth as to what was discussed. And if he couldn't recall it earlier, I think it's inappropriate for her to refresh his recollection by doing that.
Your Honor,
go ahead.
I think we could ask the court reporter what my exact question was, but I believe my question was phrased, was there a discussion? I didn't refer to November 5th. And I asked him, was there a discussion to give them additional time to document this permit application?
She's given them the subject matter of a discussion. I mean, you know, what was discussed? Not, did you discuss this? Did you discuss that?
Overruled. I'm going to allow the question.
Okay.
And Mr. Guy, was there a discussion at some point regarding giving the applicant additional time to submit documentation for this permit?
Yes, we did. That was, I mean, it was sensible to allow the applicant time to provide the necessary documents that were requested.
And when did you have that discussion?
Informally, we spoke about giving some extra time, but then after we did send a letter stating that, you know, you're given this amount of time to present, and that was a letter that came after the meeting, giving him a new deadline to submit the documentation.
Okay. And at some point, did you deny the wall-filled driveway aprons and paver permit?
Yes, that was done.
When was that?
It says with immediate effect. So it would be March 3.
Okay, and did you give them a timeline to remove the improvements under that permit application?
Yes, we did.
And what was that time frame?
This is the second part of this letter is on page 30. To be removed by April 2 of 2020.
Okay. In general, when someone applies for a building permit, who has the burden of showing they satisfy all the code requirements?
The burden of documents is on the applicant.
And when you reviewed the documentation in January of 2020, as the city's building official at that time, did you find that their documentation satisfied your request for the dock permit?
Specifically, the one document that I believe that was specific to my portfolio would be the Army Corps approval at the time of application, and that was missing. Everything else was a zoning issue, and I leave that up to the zoning professionals to make those determinations.
Okay. With regards to the dock permit, was there a permit submitted while you were the building official for the floating home that was discussed on your cross-examination?
There was not an application for a floating home at this location.
So a discussion about that Mr. Taylor established a floating home, what was that based on?
I have to be careful about that word established. My intent is to state that there were pictures of a floating home in the package that I reviewed in January of this year. And that is my statement on that.
Okay, so there was no permit application for a floating home?
There was no permit application for a floating home.
Was there any permit application for a single family residential dwelling at this property?
I do not recall any applications for a single family home at this location.
Okay. You spoke about prior communications between the prior building official, Lady March, and Mr. Taylor regarding the fill at the property and the riprap. Was that documented somewhere?
That was actually a lack of document. I didn't say there was a discussion. What I noticed is there was no request for any information with regards to fill for that property.
Was there any information that you're aware of for riprap at the property?
There was no information that addressed the height or the paved area.
Okay, so where is this coming from that a former building official told Mr. Taylor that he could put fill and riprap at his property without a permit?
I did not say that fill was approved without a permit. What I can say is that this application made no mention of any requirement for fill at the location.
Okay, but I thought on cross you had agreed with Mr. Ryan about the former building official telling Mr. Taylor he could put fill at the property without a permit.
I did not say that he could put fill. What I can say, there was no discussion about the fill, and I too had no. There was no requirement for fill. If there was no I probably would have assumed that the fill was already there. There was nothing to say that fill was going to be added, that the site needed to be filled. there was no mention whatsoever of fill at the location. So it was a
Okay.
non-issue.
Okay, so while you were the building official, you were never presented with a question about adding fill to the property?
Never.
Okay. And when you were the building official, when someone would apply for a building permit, did you require that the owner sign the application?
For a building permit?
Yes.
Yes. The city does have a kind of system that I did not perfectly agree with. I did question it, where they did allow some applications to be signed on both sides by the contractor. I don't know if I'm answering your question correctly, but it's something that I would like to see and that I asked for, that the owner also signed to make sure that the owner is in agreement with what is on the application.
Okay, so sometimes the city would just let the contractor sign both as the owner and the applicant.
Yes, I've seen those.
Okay. So based on your letters that you sent out in March of 2020, as of March 2020, was there a valid building permit for the temporary electric pole at the property?
That building permit, could you please rephrase?
Sure. Based on your March 2020 letters,
correct,
was there still a valid permit for the temporary electric pole at the property as of March 2020?
Well, what happened was that the permit was closed previously, but the time, which is the 180 day for a temporary structure, was exceeded.
So they didn't have a valid permit as of April 2020 for the temporary electric pole?
The permit was closed based on the system that they used at Riviera Beach. The permit was closed out. There was no activity at the job site. The thing is, if there's activity at a job site and there's a temporary pole, each time an inspection is called, a valid inspection, it resets the clock to 180 days. In this case, there was no activity at the location that refreshed the 180 day for a temporary structure of that nature to be in place.
Okay. As of April 2020, did the property have a valid permit for the wall?
April 2020. For the wall, so the permit was denied on the 3rd. So the answer is in March. So in April, they did not have a valid permit.
Okay, and on the dock permit, did they have a valid dock permit as of April of 2020?
That permit was denied on March 4. So it says effective immediately March 4. So in April of 2020, they did not have a permit.
Let me interrupt there for a second, Mr. Guy. I noticed you're reading from something. Can you inform us as to what you're reading from?
Oh, those are the letters from Permit File Volume 2, pages 28 to 32.
Okay.
Yeah.
Okay.
Sorry.
Very good. Thank you.
Okay.
Thank you.
I have nothing further.
I got just a little bit of recross. I apologize, Judge, if I can.
Not a problem. No. I was gonna be sure that you wanted to ask a couple follow-ups. That's fine. Go ahead.
Thank you. You talked about the stop work order process, just generally. And since we're going to talk about that a little bit, what's, Mr. Guy, what's supposed to happen after a building official issues a stop work order?
The stop work order clear as to the reasons for the stop work order, and it should also give a type of prescription as to what the client needs to do. So there should be information given to the client as to how to proceed. It could be a part of the actual stop work order, but it also could be an additional document.
Okay, and if for any reason the stop work order is not clear, should the building official be make themselves available to discuss the issue with the owner or the owner's representative, so that the corrective measures or prescriptive measures, as you said, them could be implemented?
The onus again is on the contractor to get that information if it is not clear from the building official in order to proceed.
Okay, and what the onus is on the contractor or the owner to get the information if the stop work order is not clear. What would the reasonable steps be for an owner or contractor if they saw a stop work order on their job and they needed some clarification? How would they get that clarification?
Step one, they would usually call the building department and or arrange a meeting with the official to clarify what is needed in order to correct the violation.
Would it, in your opinion, would it be inappropriate for the building official to issue a stop work order? And I don't know when the one was issued. In this case, was it July or August, whatever, and then refuse to meet or communicate with the owner as to the prescriptive measures until November 5th, 2019?
That would be unusual.
Okay. And do you have any reason to believe that that's not exactly what happened in this situation?
I do not know that this is what happened. It happened before I came to the city. And again, all I can say is that, I mean, every building official I know or intent as professionals is actually to work with a client to comply. A stop work order is not an end. It's just a notice, a very strong notice to say we need to comply. It's or intent is to work with clientele to achieve a goal, not to, you know, stop randomly any project.
So, you know, and justly so, if the building official sees something being done not to code or unsafe, the building official should, you know, put that red flag up and say, hey, wait a second, guys, you need to do things differently, and notify the contractor or the owner what they need to do differently so the work can proceed, correct?
That is correct.
And have you reviewed the stop work order that was issued to Mr. Taylor in this case?
I did not.
Okay. You testified on redirect that during the November 5th meeting, there were discussions as to the time allowed for Mr. Taylor and I to respond. And then you said that following the meeting, you sent letters to the contractors telling them the time that needed to be responded, right? But can you tell me specifically what you told Mr. Taylor and I about when we needed to respond. Not looking at documents. I want you to tell me what your memory of the discussion you had with me or Mr. Taylor on November 5th, 2019.
The discussion was additional time will be given. We did not give a date at that meeting.
So there was no
But
deadline set.
We said you will be given additional time to comply.
Okay. And that once we complied, the stop work order would be lifted, correct?
I can't recall exactly what we said would happen, or, but ultimately the goal was always for you and your client to continue construction once we have the required information.
Okay. I want to go, if I can, to the timeline that you testified about earlier. And it was page 22.
Okay.
And the bottom of my page 22, and same thing on page 21, appears to be part of the first letter of the March 11, 2019 Florida DEP letter. Do you see that?
That is correct.
Okay. Does that refresh your recollection as to whether or not you had one of those?
Well, this timeline was actually done, obviously, based on the most recent date that was there on the timeline 12/2/12. Okay. So this timeline was done possibly in January of this year. So I can't say exactly where I got this document from, but this timeline was not done on November 5th. It was done more than likely in January or February of this year. Okay.
But in any event, when you prepare this timeline, and the most recent date on this timeline is March March of 2019. Anyway, so we don't know what day you prepared this timeline, but when you did it, you had available to you this March 11th, 2019 letter from the DEP.
So the most recent date on this document would be 1/2/12/2020. So it happened after that, no, looking at it.
I'm looking at page 22.
Well,
sir.
it's actually this is actually one page. This is a continuation of the following page, or it continues on to page 23. It's not a standalone document.
Okay.
So yeah, this happened this year. This document was created this year.
Okay. So in February, at least by February of 12th of 2020, you had the March 2019 DEP letter.
It would seem so, yes.
Okay. And if you could go back to my exhibit 15, which was the 2013 DEP letter.
What page is that?
Now we've established that you've had both of them. It is exhibit 15 in my exhibits.
Exhibit 15. So 15. Is there a page number?
On the PDF, it's page 125 of Mr. Taylor's exhibits.
Okay, no, I'm here, yes. Yes, I do have that.
Okay. And we talked about this you relied on language in this 2013 exemption letter on behalf of the Army Corps to say it was expired. And now we've established that in March 11 of 2019, you had the letter saying everything is the same. But let's read the language in that paragraph again, because I've had a little more time. And about halfway down the paragraph, on the left margin, there's a sentence that starts, however. You see that? However, the activity. You see that sentence?
Where are we?
In that paragraph, you said this exemption or this verification will expire after 1 year, was words that you were relying on.
Okay.
And then it goes on and says, will not be valid at any of those times if site conditions materially change. Right?
Correct.
Then it continues. After that sentence, there's another sentence that starts with the word however.
Okay, however, the activity may still be conducted without further notification
or verification from the department after the 1 year expiration of this verification, provided the project design does not change, site conditions do not materially change, and there are no changes to the status or rules governing the exempt activity.
Correct.
Did you do anything to determine whether or not the design had changed, or the site conditions had changed, or whether the rules governing exempt activity had changed?
Again, I had no, nothing connecting the denied application in 2014. All I had was notes in a database.
But based on these two letters from the DEP that you had, the one in 13 and the one in 19, you had no reason to believe that this, where it says federal review granted, was not still valid.
Okay, so we had a meeting on November 5th, all right? And I was told in that meeting that you guys had an effective permit application that covered the date that the permit was issued. Is a document from 2013. It didn't say it was valid at the time when the permit was issued.
Well, it says, however, the activity may still be conducted without
again. I did not have the first permit that was denied to make a comparison, and I made the decision based on what I have here that it was not clear evidence that there was an active U.S. Army Corps permit at the time the permit was issued.
So if you interpreted these documents incorrectly, that was your error, not Mr. Taylor's.
You might be interpreting it incorrectly too, sir. I mean, I made my interpretation.
Okay. You were asked on redirect about the no valid wall permit. And I can't remember exactly how the question went, but it brought to my attention a fact that I don't think you've been asked about, and that is, are you aware, or were you aware when you revoked the wall permit in March of 2020 that that wall was in place of a fence that had been permitted and in place for over 30 years?
I was not aware of a fence that existed, but that was not my basis. My basis was that it did not meet the zoning requirements and did not pass zoning review, and it did not provide information and meeting the requirements of a zoning approval to be issued.
Well, and to be clear, you didn't make any determination that it didn't meet zoning requirements. You were just told to tell Mr. Taylor that your wall doesn't meet zoning requirements. You didn't determine
as
that.
a condition of a building permit other agencies. I understand zoning to be another agency that requires to approve a permit in conjunction with a building permit that is being issued for improvements having to do with a wall and pavers.
And other than this March letter telling Mr. Taylor that for zoning reasons your wall permit's revoked, you don't have any record of ever telling Mr. Taylor what was wrong with the wall or what information he needed to provide?
Personally, no. Everything having to do with that is strictly zoning.
Okay. No further questions, Judge.
Your Honor, I have some redirect.
This is
Mr.
gonna
Guy,
be-
what's that?
Never mind. Go ahead.
It may never end. Is that what you're going to ask? Mr. Guy, if we go to Mr. Taylor's Exhibit 15, which is the June 18th, 2013 letter.
What
from-
page is that, please?
It's on the PDF at 125.
Oh, yes, I'm here. Yes.
Okay. On page, that's a 4-page document. On page 3, is there any further information on that page regarding how long this approval exists?
On page 3.
Yeah, page 3 of 4.
Okay. The determination is based on the information you provided to the department, and statuses and rules in effect when application was submitted is effective only for the specific activity proposed. The determination shall automatically expire if the site conditions materially change or the governing statutes or rules are amended. In addition, any substantial modification in your plan should be submitted to the department for review, as such changes may result in the permit being required. In any event, the determination shall expire after 1 year.
Okay, and when did they apply for the dock permit with the city of Riviera Beach?
That would be in 2019, 6 years after this permit and 5 years after it would have automatically expired, according to my determination.
Okay, and in your timeline in the city's permit file, there's that Florida Department of Environmental Protection letter from March 11th of 2019.
Right.
Do you recall if this letter gave them a United States Army Corps of Engineers authorization to install the dock?
I don't recall, I'll be honest. Yeah,
If this letter gave them the U.S. Army Corps of Engineers for the dock, would have that resolved the issue for you?
Absolutely.
I have nothing further, Your Honor.
Okay, Mr. Guy. Thank you. You've endured some lengthy testimony here today. We definitely appreciate you appearing and being patient and going through this. I'm going to excuse you now, so you can be dismissed at this time.
Thank you very much.
Thank you, sir.
Thank you, Mr. Ryan. Thank you, Ms. Christie.
Thank you. Thank you.
Thank you, Judge.
Okay, Ms. Godot and Mr. Ryan, it is 11:52. Let's do some planning here. Ms. Godot, how many more witnesses do you have?
Your Honor, at this time, I anticipate just calling Jeff Gagnon on our case in chief.
Okay, and I'm assuming that's going to take some time between direct and cross.
Yes.
Mr. Ryan, how many witnesses do you have?
I have 1, 2, 3, 4, 5 witnesses, but I'll tell you right up front that I requested that the city either agree to produce or subpoena 2 of them, and the city said they would not, but that instead they would argue that it was irrelevant that these witnesses participate. And so I don't know whether or not they're going to be available. One being Dr. Julia Botel, who had a meeting with Mr. Gagnon and Mr. Taylor and the city manager to discuss this work. And the other is Dawn Wynn, the city attorney, who made phone calls to Mr. Taylor between the time the stop work order was issued and the time Mr. Guy became employed with the city. And their testimony, I think, is relevant for a couple of reasons, in addition to those direct conversations that they had with the party. So, and I'm not clear whether or not Ms. Godot said she was having Mr. Gagnon and somebody she referred to as the chief. I don't know, or whether it was just Mr. Gagnon. It wasn't clear to me.
Well, I see Mr. Gagnon is on the call, so he is here.
Yes, Your Honor. My next witness for my case in chief.
Case in chief, gotcha. I apologize.
Okay, all right. I think that's where that came from. Will be Jeff Gagnon.
Okay, okay.
To clarify, Mr. Ryan did request to have Councilwoman Dr. Botel as a witness, and he did also request the city attorney, Dawn Wynn. As to Dr. Botel, as you know, to have a council person come testify is highly unusual, and there's case law that states if the testimony can come from somebody who's more immediate to the situation, that's how the testimony should be brought in. So Mr. Gagnon will be my next witness, and if he was in the meeting with Dr. Botel, he can testify, and Mr. Ryan can cross-examine him on the contents and the discussions in that meetings, and there's no reason to call Dr. Botel, who's a councilwoman for the city. Now, as to Dawn Wynn, my concern was, and Mr. Ryan, when he asked for Dawn Wynn to be a witness, he did not say it was very limited testimony regarding calls she made to Mr. Taylor. My concern was, as the city attorney with multiple cases pending in litigation, that he would be asking her questions that would dive into attorney-client privilege conversations. And if those discussions could be had through another witness, that would certainly be the city's preference. Now, he's changed his tune somewhat today with me to say all he wants to ask her about is these telephone conversations with Mr. Taylor. There's nothing that prevents Mr. Taylor from testifying as to the contents of those discussions.
Well, what I'm going to do is basically cross those bridges when we get to it. I'll say that I am leaning against allowing the calling of those 2 witnesses for obvious reasons, but I'll state them more specifically when we get to it. So it seems like, let's see, you got 1 more witness, Ms. Godot, and Mr. Ryan, you have about at least 4 or 5 that you want to call, maybe 3 if the 2 I'm leaning against allowing the 5 come through. So let's break for lunch now. I mean, it's virtually 12 o'clock. I guess 1 o'clock is a fair time. So let's break for lunch and convene at 1.
Thank to all. Thank you for your patience. And I'm going to put my hearing aid device on a charger over lunchtime so that we don't end up having trouble at the end of the day.
All right,
Yes.
thank you, Mr. Ryan.
Thank
Thank
you
you.
all. We are adjourned to 1.
Thank you.
Thank you.
Thank you. Heidi?